than that. Ooh. Okay. I didn't put my Zoom on. Right, do I need to have the Zoom on?
I know Ms. Gomez was going to zoom in if it was
Oh, okay, then I'll put it on. Okay, just give me a minute. Thank you. I brought another box. I'm like,
Vanessa told me.
in my nose.
I guess. Just put it.
Okay, let's go on the record. State of Florida versus George Pino. Parties can announce, please.
Good afternoon, Your Honor, Laura Adams and Jonathan Forrest on behalf of the state.
Good afternoon, Judge. On behalf of Mr. Pino, who's waiving his presence today,
Right?
I'm accompanied by my law partner, Mark Shapiro, Edward Arbolino. Good morning, Judge. Today, Alexa Klein is with us.
Okay.
I should have said my name is Howard Strutman.
Okay, very good. Thank you. And it's no problem for Mr. Pino not to be here today because we are, and he's, of course, can be if he wished. We're just going to be conducting our charge conference. I want to go through the jury instructions, and thank you, everyone. You all sent me your proposed instructions, and I think really the meat of it will be for me to address the manslaughter instruction, the vessel homicide instruction, and the request for an instruction on the navigational rules. Okay.
Agreed.
So, you each have your copies of what you provided to me, correct? You have your copies of what...
To be clear, earlier, over the weekend, last weekend, we may have sent you...
Yes, but it's been updated.
Yes, what we did today was we sent you the correct Word version
Perfect.
of what we had sent you in a PDF. There was a mismatch. Now you have exactly what we intended you would have as of last week. Today we will have some additional requests to go over with you.
Okay.
So you should have, from our perspective, we proposed doing it on the
I
computer.
have yours here.
Using paper.
I have the states here, and I have mine here. Okay, so perfect. Thank you for doing that. Okay.
And we also have the ability to put it on the screen if we want to read along with you. That's up to
Oh,
you.
that's okay. Sure. But as long as you all have copies, you can follow along as we're going through. So I think, you know, just to... I'm just going to go page by page, and when we get to the instructions that we'll have further discussion on, we'll stop and we'll talk about it, okay? So, the introductory, which I would call page 1, is just the introduction to the final instructions. And if I don't hear any objections, I'm just going to put a check mark and say that it's clear. Okay? All right, so that's clear. Then we go to what would be page 2, which would be statement of the charge, of the charges. And we'll have both crimes of manslaughter and vessel homicide. And there are no objections that I'm hearing. All right, so then we get to introduction to homicide. And the standard instructions, from the way I understand them, is this instruction, if there is a death or manslaughter, there's a manslaughter charge, I have to give the introduction to homicide with what would be excusable and definitions of excusable and justifiable homicide. So while it was crossed at that, it was X'd out in the defense filing. You all want to talk about that?
Sure. Would you like us to stand or can we remain seated?
You could sit, that's fine.
So, the state is proceeding, we believe, we're talking about manslaughter now.
Well, I'm talking about, again, yeah, it would be, well, and I'll ask to state this, for the introduction to homicide instruction, all right?
Yes.
That would be 7.1
Correct.
of the jury instructions. Now, it must be read in all murder and manslaughter cases. So, I would not have vessel homicide in there and referred to anyway, because it's to be read in all murder and manslaughter cases under the rules.
Judge, I'm going to double check because in any DUI manslaughter case,
Manslaughter, right. But I'm talking
Right.
about vessel homicide. I don't think I'm going to say vessel homicide. I think it's manslaughter is unlawful because you charge it as a DUI manslaughter, but what you have here is the vessel homicide is a separate, under a separate statute.
Sorry, Judge, did you say DUI?
I mean, I thought the state just said that it's not a, if anything, it would be a BUI, but we don't have a BUI charge. And again, I'm looking at my rules and the 2026, and it says read in all murder and manslaughter cases, and I don't.
the reason why I'm going to try to find a case for Your Honor, but the reason why I think it's important to read as to both of the homicide charges is because the excusable homicide instruction that the court would give as a part of the introduction to homicide, I think applies both to vehicular and vessel homicide, because not every death, whether it's by a vehicle or a vessel, is necessarily going to be criminal. It can wind up that it is an excusable homicide. So if we can hold off on that, I just want to see if I can find a case that substantiates that. But I think it's important that the jury understands that if they find that this was an excusable homicide, whether it's as to vessel homicide or to manslaughter, that the elements of excusable are applicable to any of those charges.
Okay, and I think the defense, I don't want to speak for you. It seems to me that your position is that you don't think it should be given at all.
No, I think, just give me 1 second.
Because it was crossed out on your
Yeah, so-
feeds.
So we agree that excusable homicide should be explained to the jury, but think that justifiable is not relevant to the case.
It may not be, Judge, but again, that goes along with the standard instructions, which is that the jury needs to be placed on notice that just because a death results, it's not always going to be criminal. For example, justifiable use of deadly force. Nobody's saying here that, obviously this is a self-defense case, but I think it's important for the jury to have context within which homicide charges are brought. And that's why I think the instructions for this instruction say it is to be read in all murder and manslaughter cases.
Well, I think that then the question is whether or not it's anything that could be waived. It may not be, I don't know if it is something that, I think it goes together with the entire introduction to homicide instructions. When you look under 7.1, yeah, it's part of the instruction, so I don't know of a case where part of it can be waived and part of it included. I think the way the instruction reads requires me to read the entire instruction on introduction to homicide in these two subparts.
So I don't understand why it would be read if this is not a case of, for example, self-defense or some other explanation. And I think it's just going to confuse the jury on the issues that are before it. Because justifiable homicide is actually an affirmative defense, I believe. So now we're raising it sort of implies that the defendant has to show justification in a case that has nothing to do with that.
But, Your Honor, like, if we were trying a case of, felony murder and there's no hint of any kind of self-defense in the case, the court would still be reading this instruction. It's not confusing. It's very easy to explain to the jury, and defense counsel and I can talk to the jurors about it, but it's very clear. It's to be read in all murder and manslaughter cases. And when it's called Introduction to Homicide, I think it's kind of self-evident that it's any time that one person is charged with causing the death of another. That's a homicide.
When the prosecutor is talking about, is that what the book says that it's supposed to be done, or the Supreme Court is saying it's supposed to be done? I'm not sure. But what is it that the jury is supposed to do with that instruction? When they're deliberating, what are they supposed to do with it? Why would they even refer to it? We're giving them information that is supposed to be useful to them. How is that information to be used in the jury room? When they're talking about, okay, what do we do with this justifiable homicide business? Why are they talking about that in there? And if they're not supposed to be talking about it, why are we telling them about it?
Okay, I have to reserve on that aspect. The rest of the instruction I would give.
What's the rest of it?
On introduction to homicide. I'm going to reserve right now because I just want to look up a few things, see if there's, any cases on that. Because the purpose of the instruction is also to give the jury a clear statement of the law, but also not to confuse the jury. The same reasoning applies, for example, when anyone's making a request for special instruction, or there are some requests here, and I'll get to that in a minute. Whether the instruction itself clearly explains the law, but if it's something that is particularly not applicable given the facts of the case, are we putting the jury in a situation where it might be confusing?
Yeah. So that I'm trying to understand.
I've always I have to say, as a matter of, because it's in the same instruction, there's not two separate instructions, although they're highlighted as under different subsections of the statute. This is not a case of justifiable homicide.
Correct, and the way it's currently phrased, the very first page, end of the second paragraph, it says, after introducing the concept of justifiable use of deadly force, it says, if you find Luciana was killed by Pino, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Now, why are they going to be thinking about that at all? Why are we telling them?
I understand your point.
Good.
And I am going to give consideration to excising it out, because again, the instructions, they're the standard instructions, but also not to confuse the jury. Or maybe some modified instruction that, you know, this is not a case, or reading the instruction and telling the jury this is not a case for you to consider any kind of justifiable homicide. But I think that makes it more confusing and brings up matters that are irrelevant for their consideration. So I'm going to think about that, okay? Excusable homicide, that will stay in.
And if I could address that one, because there may be some cause for confusion. So I'm reading the state's proposed instruction where it says the killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances.
Okay.
Okay. 2 and 3 do not apply in this case because this is not a heat of passion case and it's not sudden combat.
Okay.
So.
Well, again, I'm not going to get to the point where I'm then carving up what the standard instructions are. In argument, in your final arguments to the jury, you'll have a copy of the instructions, and it would be an opportunity to, if you felt it necessary, to just explain that there's no, you know, none of this applies. Something wrong.
So, okay, so you understand my objection and you'll rule on that. But let's go back to number 1.
Okay.
When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. The phrase usual ordinary caution implies not negligent. That's ordinary caution, I believe. It's implying that something beyond that failure to, let me say that again, negligence would render the homicide unlawful. That is, that the person, Mr. Pino, did not exercise usual ordinary caution. That's, as I understand it,
Well, that's your argument in terms of a defense to, you know, whether the conduct rises to the level of culpable negligence.
I agree, that's my argument. I'm afraid that this jury instruction is suggesting that if he did not act with usual ordinary caution, he's guilty. The state has to prove that he did not act. They have to prove he acted culpably negligent or, in vessel homicide, reckless.
Right.
Right? And so the way paragraph 1 of the excusable homicide instruction reads, as I read it, is that it's a defense so long as he was doing a lawful act by lawful means with usual ordinary caution. Right? So he has to prove he was not negligent.
When it's committed by accident and misfortune.
Yes, but an accident can be mere negligence.
Yeah.
Right?
Okay.
Okay.
So I'm not sure what the issue is.
And let me just give it one more look. It's because mere negligence is not enough to convict.
Okay.
And this is implying that he has to be not negligent in order to benefit from excusable homicide. Am I right? Yeah, negligence is the failure to use ordinary caution.
Okay.
So unless I'm misreading it, I think what this is telling the jury is that to have the defense of excusable homicide, you must be acting with usual ordinary caution. That means you, Mr. Pino, must not be negligent to be excused. It's implying that if he was negligent, he's guilty.
No, but he's not, your theory of defense is not that he should be excused, but rather he wasn't culpably negligent and/or reckless.
Yes, but this instruction seems to say otherwise. It seems to say that excusal, meaning excusal requires that he use ordinary caution, which conflicts with the theory that the state has to prove culpable negligence or recklessness.
But aren't these affirmative defenses, reading in the context of what would be an affirmative defense?
I don't know, but it shouldn't be an affirmative defense. It's the state's burden to prove he acted with culpable negligence or recklessness. It's not our burden to prove that Mr. Pino
No, this
acted
is just, but in the definition of homicide, and where a homicide, when a death occurs in a homicide, okay, the individual accused would be excused from any kind of criminal liability if the killing was done by accident and misfortune while
not being negligent.
While using ordinary caution.
That term, ordinary caution, means not negligent.
And without any unlawful intent. You have to have no unlawful intent.
So it's putting the burden on us, Mr. Pino, to prove he was acting with ordinary caution, meaning he was not negligent.
I don't think it shifts the burden.
Well, it says.
Your Honor, if I can just interject, this instruction comes straight from Florida statute 782.03. So maybe the defense wants to look at that statute because this instruction just mirrors what the statute is. So I don't know why
it's exactly what is in the statute. Review that. I hear your argument that this instruction, your contention is, shifts the burden to the defense to do something, but I don't read it that way. Well, I understand what your point is. I don't read it that way. This is just, defining what homicide and what would be, again, I'm using the word excusable. It's in the definition, and that's the definition of what would be considered an excusable death. I don't think it shifts the burden or puts any responsibility.
So maybe I should ask, what is an example of an excusable homicide that's not, let's say, a justifiable homicide?
An excusable homicide might be a person is driving their car down the street in a lawful manner, and a kid runs out in front of the car, and the person runs the kid over, and unfortunately the child dies. That would be considered an excusable homicide. If for some reason a prosecutor wanted to bring charges, then the defense would arguably be able to say, no, this is an excusable homicide because my client, this was an accident, this is misfortune, he was doing a lawful act by lawful means with ordinary caution without any unlawful intent. That's exactly what 782.03 envisions, and this statute, this instruction simply puts words to that statute.
If there's a presentation of an affirmative defense, there's no requirement on the defense to, there's still no requirement on the defense to present any affirmative evidence.
So if the court, hang on 1 second. Yeah, so our view is if the court is going to give us the choice between having that paragraph 1 and reject my suggestion that it should be modified, I would ask that no instruction be given on excusable homicide.
Okay, that's your request. All right, what's the state's position?
Well, the state's position, Your Honor, is that it has to be given because it's the law. 782.03 couldn't be more clear. And literally, if they don't want it to apply, that just seems, I can't understand why the defense wouldn't want an instruction that's supposed to be read in all homicide cases. It's introduction to homicide. I guess they think it's maybe not good for their client, but we're not going to stack the instructions to be pro-state or pro-defense. They're just supposed to acknowledge what the law is.
Right, well, as standard instructions. So, under the circumstances, I'm required to give what would be standard instructions. okay, in every case. Whether, this says, of course, in the introduction to homicide, it's a manslaughter, and that's why I brought up the question of how vessel homicide, because it doesn't say specifically, I mean, a death occurs, but manslaughter and the elements of manslaughter are different, right, than the vessel homicide. So that's why I said that I don't know whether or not I would be including vessel homicide in the instruction. I would say manslaughter is unlawful. A killing that was excusable or that was committed by justifiable use of deadly force is lawful. And then I go, because if you read the instruction, do you have the book in front of you?
No, but I can pull it up if you tell me where to look.
Yeah, it's 7.1. It's the 2026 standard instructions.
7.1.
So if you go through the 7.1 instruction, let it be read in all murder and manslaughter cases. Okay, there's a manslaughter charge here.
So I have to object, and just as a point of reference, in the 11th Circuit, I had argued a case that the pattern instructions were mistaken, and the case resulted in a reversal, a case called United States versus Tackalaw, and the standard instructions were then changed because they were wrong. I don't think these instructions are that you must give them if they conflict with another instruction. So let's ask, how is the state going to use that instruction in its closing argument, and how is the jury supposed to use that phrase that we just talked about, where it says it's an excuse if the defendant is acting with ordinary caution. It implies that it's no excuse if he's acting negligently. And then, because that's what ordinary caution means.
No, but if the jury does not find something more than ordinary caution, then your client's not guilty.
Except that instruction seems to say otherwise. It seems to say he's only excused if he acts with ordinary caution.
There's other parts to that.
Well, then that's why I'm saying they conflict with each other.
I'm not sure I agree. But
Let's just hope the state doesn't argue in closing using that instruction and say, here it is right here. He's only excused if it's ordinary caution.
I would think that would be an improper argument.
Which is why I don't want the instruction submitted to the jury.
Okay. I hear what you're saying. So, for now, just to let you all know, while I ponder this, I'm inclined to give the introduction to homicide instruction. I'm considering whether or not I would excise out justifiable homicide, because under no circumstances do I see that even relevant to this case. And in terms of the definition and excusable homicide, at this point I'm inclined to give the instruction as it appears in the standard instructions. Your objections are noted, and I'm still deciding whether or not, and I'm really not inclined to give justifiable homicide. I just think that might be a cause of confusion and unnecessary confusion for the jury, and I don't see at all how. I think it's worse to put the onus on either party to argue to the jury in closing, by the way, you see these are the instructions, but disregard this, rather than just not have it there. I just don't see how at all excusable homicide applies. So, I mean justifiable homicide. Okay? So, for now, excusable will stay in. I'm going to excise out justifiable homicide and then give the rest of the instruction. Okay.
Objection noted, Your Honor.
Let's go to the instruction on manslaughter.